Well, I don't know what she filed. I mean, she didn't say anything in her filing, so, but that's fine. You want to consolidate it, I don't have an issue with that. We can provide you documentation
Well,
as
you
to
can
what
have an
happened.
issue with anything. All I'm trying to do is get to the bottom of this. Bottom line. That's all I want to know. So she can have her objections. You can have your objections. We're going to do it my way. Go ahead, man.
Before we even step into this courtroom, let's set the stage. A young defendant, her mother fiercely at her side, and a judge who's seen it all. The stakes, thousands of dollars, accusations of theft, and a tangled web of promises and broken trust. But beneath the legal jargon, there's something more, an undercurrent of pride, frustration, and the desperate need to be heard. As you watch, ask yourself, is this just a case about unpaid rent, or is it about something deeper: respect, responsibility, and the consequences of our choices? Buckle up, because this hearing is about to get heated.
Harbor One West versus Rosa Bannock.
Cheryl Wolkoff on behalf of the plaintiff.
She was at $35.71 and she's or $3,500.71. She's still at that.
She is, Your Honor, and this is one where an answer, I believe you told her to file an answer. She filed it. The court sent it to me. It doesn't say anything. There's no attachment. I'm not sure what the defenses are. And frankly, Your Honor, I don't know if you recall, but this particular resident was in another unit. We generously waived her entire balance because she had repair issues. We moved her into a new.
Did you catch that? The defendant claims she was locked out in the middle of moving and that her belongings, including a firearm, were stolen. That's not just a logistical nightmare. It's a legal minefield. In landlord-tenant disputes, the timing of possession and access is everything. If the landlord changed the locks too soon, they could be liable for damages. But if the tenant failed to remove her property in time, the responsibility might shift. The judge's job to cut through the emotion and find the facts. But as you'll see, that's easier said than done when both sides are digging
Unit,
in.
now she hasn't paid any rent.
I was locked out in the middle of moving.
Sorry.
I was locked out in the middle of moving and they didn't help me with like what we agreed upon.
You were locked out and they didn't help you. What do you mean by that?
So remember how we were talking about how I couldn't afford a moving truck and that they will figure out something for me.
Right.
They locked me out in the middle of moving. And when we got access, which was end of May, a lot of my stuff was stolen, including a firearm, all my small kitchen appliances, my daughter's brand new sheets, my security cameras.
So what do you mean they locked you out? I don't get it.
Like we didn't have access. Like they changed the locks.
On your
On my
previous.
yes. I did not render the old keys. And also
So in essence, so I just want to shortcut this. In essence, you're saying they changed the locks before you got all your stuff out.
I don't know what to do at this point.
Your Honor, if I can add, I would respond, but I'd rather have Amy respond because she has direct knowledge of what happened, because I don't believe that's our position. And I also don't believe it's relevant to this case, but that's a separate issue. I think it's worth responding to.
Here's where things get morally murky. The landlord's representative insists they gave extraordinary grace, even moving the tenant to a new unit and waiving previous debts. But the tenant's story is one of chaos, lost property, and broken promises. Who do you believe? And more importantly, what does the law say about a landlord's duty to safeguard a tenant's belongings after a move? This is where legal nuance meets real-life heartbreak. If you were the judge, would you side with the letter of the lease or the spirit of fairness? Let us know in the comments. This is where the debate gets real.
Your Honor, that's absolutely not factual. She signed a whole new lease, and I don't think I don't think Ms. Lutkoff or anyone would volunteer us to pay for a moving truck or use my maintenance guys to move her belongings, which is what Ms. Bannock seems to be under the impression that we offered her in court. She was given plenty of opportunity. In fact, there was a lot of grace given here to remove her stuff. And in fact, she came in our office on several occasions saying she didn't have a babysitter. She had to work. Her boyfriend had to work, all these reasons. I locked down the apartment upon her signing a new lease, sir, she took possession of a new apartment, Your Honor. And yes, I locked down the unit. She did turn in keys to our box. And so I took possession of an apartment that she no longer had possession of, Your Honor. And she left
Oh, was there
belongings.
stuff in there?
Yes, my
There
stuff
was,
was in
there
there,
was
and I have the keys
boxes,
right now.
I believe.
I have the keys.
So what?
The keys
I
are
mean,
in my
I
back.
can't say whether she kept a set of keys or not, Your Honor, but what I do know is that way later after the fact, after she's been in this other apartment for quite some time, she's bringing up issues of stuff that she wanted out of the old apartment. And at that time, I had already started a trash out, Your Honor. I mean, she signed a whole nother lease.
Your Honor, I think there was an issue.
I understand she signed a whole nother lease, but I'm just trying to figure out what period in time are we talking about?
I have a timeline. So
Your Honor,
we
I'm
didn't
going
gain,
to just state for the record here that factually, just from a legal perspective, if she wants to pursue, she certainly can file an action for damages if she feels that her property has been damaged on another unit, but we're in court on this unit.
Notice how the judge draws a hard line. Factually, just from a legal perspective, if she wants to pursue, she certainly can file an action for damages if she feels that her property has been damaged on another unit, but we're in court on this unit. This is classic judicial compartmentalization, keeping the issues separate, even when the human stories are tangled. But is that always just? Sometimes, the law's need for order clashes with the messy reality of people's lives. Should the judge have allowed the property loss to factor into this case? Or is it right to demand a separate lawsuit? Sound off below, justice isn't always black and white.
And so I don't believe it's
Well,
relevant.
yeah, but this unit, Ms. Luckoff, that's disingenuous because this unit only comes about because of the issues that were in the other unit. So to try to separate them out doesn't make much sense.
Well, I think it does, Your Honor, because she didn't remove her belongings, but obviously this is your courtroom.
Okay,
I'm
but
just-
that may be a defense to what she's claiming if she didn't remove the items. That may be a defense, but to say it has to be a whole another separate thing, I don't think that that's true.
Well, I do, because we're talking about a certain property
Okay,
address.
then
None of
I'll
that,
take what she filed. I'll tell her to go up there, stamp it in as another case, and it's just coming back with this one. I don't know where that gets us.
well, I don't know what she filed. I mean, she didn't say anything in her filing, so, but that's fine. You want to consolidate it, I don't have an issue with that. We can provide you documentation
Well,
as
you
to
can
what
have an
happened.
issue with anything. All I'm trying to do is get to the bottom of this. Bottom line. That's all I want to know. And I want to know where I'm going to take this case. So she can have her objections, you can have your objections. We're going to do it my way. Go ahead, man.
all right. So the reason why we're here is because I feel like I can't trust their maintenance people because my stuff was stolen. I don't want anyone coming into my apartment.
Ma'am, you were at the point of a timeline.
Yeah. So the timeline is I think we did our court date like April 26th, I think. And that's when we dismissed the case, which honestly, I wish we had set things and whatever. And then that next week or that Friday or whatever they had to finish with the apartment, I think we grabbed the keys like that Friday. So then we started that weekend because I was working 2 to 10:30. So we were putting the kids to bed and then we were getting the stuff. Plus, like I said,
Okay, fine.
couldn't move it.
So how much time passed between the time that you got the keys to the new place?
It was like a week and 3 days. And
So
then we
10
lost,
days
yeah,
passed.
and we lost access for 3 weeks. We didn't get this.
Oh, ma'am, stop. You had after you moved into the other apartment, you had access for 10 days
Basically, yeah.
and you couldn't get all of your stuff out in 10 days.
No.
Okay, that's going to be a problem for you.
And there it is, the judge's patience wears thin. You don't get 30 days to move out. The teen and her mother are learning in real time that the court doesn't operate on sympathy or convenience. The law is clear. Once you're given notice and a new lease, the clock starts ticking. But what about the promises of help? The confusion over access? This is where arrogance and defensiveness collide with cold, hard deadlines. If you've ever felt the system was stacked against you, this moment hits hard. But is the judge being harsh or just upholding the rules? Would you have handled it differently?
they can't hold the apartment open for you to go in and move out in that fashion. You don't get 30 days to move out.
I understand. It would have been quicker if we could have just had that one last day.
Ma'am, I'll be honest with you. If you're telling me, you made it sound initially like they locked you out, and that's all I was trying to get to the bottom of.
Yeah.
They didn't do that. It seems like, and by what you're telling me, you get the other unit, you've got 10 days. And you don't get all your property out in 10 days.
Well, technically, we didn't even have 10 days. They only gave us a week, but
Okay, and that's even my point.
Yeah.
My point is 10 days would be extraordinary grace to get your stuff out.
Yeah.
A week, maybe about normal.
Mhm.
Let you move from one unit to the next unit. Maybe
what
get
about the previous agreement that some help was going to happen?
Ma'am, I don't recall that being
Can
the
we look
issue.
over the transcripts, please?
The transcripts of what? If you want to order
Okay.
transcripts, you can.
I tried. I haven't gotten a response.
Your Honor, I have not received a request for any.
It
You,
was a month and a half ago, granted. Sorry.
no, ma'am. You made a request for transcripts to my staff?
Yes, I did. I called and then they told me to email her.
Email who?
Whoever, I don't remember the name.
Well, you're gonna have to show me that email, because I'm gonna be honest with you. If you're telling me my staff did not respond to you or did not address that,
Okay, give me 1 second.
sure. Ma'am, while you're looking for that, who was supposed to help you move?
I'm not sure. Apparently, I mean, it said that they will figure something out because I literally said I could not afford a moving truck.
Ma'am? Okay. So you go over to this new unit and you have not paid any rent in that new unit. And your justification for not paying rent in the new unit is because things got stolen from your other unit.
There's some major issues with my new unit though. And they said it was good to go. It's not good. It was not good to go.
Ma'am, you paid no rent. Nothing.
This is the turning point. The judge, clearly frustrated, calls out the defendant for not paying any rent in the new unit, despite her claims of stolen property and unresolved issues. The tension is palpable. The teen's mother tries to justify, but the judge isn't having it. You paid no rent. Nothing. In court, excuses only go so far. But here's the real question. Should hardship and past grievances excuse current obligations? Or does accountability mean paying up, no matter what? This is the kind of moral dilemma that keeps us glued to courtroom drama. What's your verdict?
I don't think it's okay to steal someone's stuff,
Well, they didn't steal it.
except they did because we made an
You know
agreement.
what? Here's what we're going to do. We're going to set this for a trial. We're going to set this for a trial on an expedited basis. Because did you find that email to my staff? Because I don't believe that you're telling me the truth. Because, ma'am, I'm going to tell you what. When somebody tells me my staff didn't respond,
I did call up here. I will say that.
but you said you sent an email.
Yes, unless it didn't. Oh, it didn't. Well, I have it on here, but I didn't send it apparently.
Well, I'm not going to make you apologize to my staff for trying to say they didn't
No,
respond.
apologize.
No, ma'am, I'm just going to tell you right now. Here's how I work. And my staff knows this. If somebody wants something from them and they're supposed to provide it, they provide it. If you come up in here and you tell me that my staff didn't do it, didn't order the transcript, that they didn't respond to it, you want to ruffle my feathers, you insult my staff.
I just.
So
I don't know.
I'll consider anything you're saying about that afterwards, just an apology to Emily.
Okay.
I'm just gonna set this for, well, I'm just gonna set it for trial. The final settlement conference is gonna work. Give me a trial date on a Tuesday
I can't.
of this month.
Could we possibly set it for August?
No, ma'am, I'm not gonna delay this out. You paid no rent.
Okay, but I have a class on Tuesday.
Ma'am, I get, we all have different things on Tuesdays. We all have different things, different times. I'm gonna set it for trial. You've not paid them any rent. You're claiming that they stole your stuff. You're claiming that they didn't help you. Well, I'm gonna get to the bottom of it, if that's what it is. So I'm gonna set non-jury trial in this matter
Are we
for
like,
July 23rd.
so does that mean like jury and stuff?
No, ma'am, no jury was requested. July 23rd, 2024. That will be at 9 a.m. That will be in person. Ma'am, you make sure that you have all of your witnesses, all of your evidence. We'll hear it then, and then I'll make my decision.
Your Honor, can I just ask you, because I know I've on that day, I have another, I don't think it's at 9 a.m. Let me see. Oh, it is. Okay. All right. And I understand you want this one in person. So I'm not going to request, even though it's past the deadline. Okay. Thank you.
Thank you.
And just like that,
we all
judge
have
brings down
different
the
things
gavel
on
setting the trial
Tuesdays. We all
date,
have different
refusing
things,
to
different
delay
times.
and making it
I'm
clear
going to set it for
this
trial.
court runs on facts,
You've not
not
paid them
feelings for the
any
teen
rent.
and her mother.
You're
It's a
claiming
tough
that they
lesson in
stole
legal
your
reality.
stuff.
For
You're
the rest
claiming
of
that they
us,
didn't help
it's a
you.
window into how
Well,
justice
I'm
is
gonna get
decided
to the
not by
bottom
who
of it,
shouts the
if
loudest,
that's what it
but
is.
by who brings
So,
the
I'm gonna
evidence.
set non-jury
If this
trial in
case
this
stunned you
matter.
like it did us, smash that like button, comment your verdict below,
Are we like,
For
and
July
subscribe for more
23rd.
courtroom
so
breakdowns
does that
every
mean
week.
like jury
Because in this
and stuff?
courtroom,
No,
every
ma'am.
story
No
is a
jury
lesson
was
and every
requested.
verdict
July
a new debate.
23rd,